For those that don't know, I'm Anthony Nedwicki. I'm the Dean of the Golden Gate University School of Law. I want to welcome you here to this exciting presentation. This idea grew out during the actual confirmation process that maybe we need to do something and have a discussion about this particular process. For me, I'm an employment discrimination lawyer, and so watching those hearings were very reminiscent of the Anita Hill hearings back many years ago. But what I used as an example of sexual harassment and the treatment of sexual harassment law at the time. So this was a really very interesting period for us. And I know around the school there were tons of, all the TVs were on and everyone was watching it very closely. And so we have, a lot of interest here on the confirmation process, but also a lot of interest about what the Supreme Court is going to look like now that Kavanaugh has joined the bench. And so today, we're really happy to be able to welcome the president from ACS today to join our discussion, and one of our professors, about the Kavanaugh confirmation process and the impact that he'll have on the court. I have a real deep interest, and I'm very proud to say that I've been with ACS, a supporter of ACS from the very beginning. I've been a faculty advisor, first faculty advisor at two previous schools that I worked at. And I was sharing that I have a couple of my best memories as a professor related to ACS. So I went to their national conference in 2003, and this was right after Lawrence v. Texas was decided. And Ruth Bader Ginsburg, as most of the students here know, is somebody, a big idol of mine, spoke at lunch that day and talked a lot about the influence of international precedent and international materials in Supreme Court cases, and that was a big issue, a heated issue at the time, and it seeped its way into the Lawrence decision. But that was the very interesting discussion, and the first time I saw her actually speak. But the more interesting and fun thing for me that day was later that night at the convention they had a Janet Reno dance party, and I got to dance with Janet Reno. So I have very fond memories of ACS. So ACS has done a lot of great things and really have moved law schools and the legal profession to look at things from a progressive bent. The Federalist Society has been very good over the history in terms of building up a strong bench, and ACS came in to do the same thing. I know at one of my former schools, I was enemy number one for the Federalist Society because we started at the ACS, because I think they knew the possibilities, and that's been realized. So let me introduce a couple of our two guests today. President Fredrickson joined ACS in 2009 as their president. During her tenure, ACS has grown significantly. They have chapters in almost every law school. They've got thousands of members across the country, and they've got chapters in almost all the states. Before she joined ACS, she was a director of ACLU's Washington Legislative Office, a general counsel and legal director of NARAL Pro-Choice America. She served as chief of staff to Senator Maria Cantwell of Washington, and deputy chief of staff to Senate Democratic leader at the time, Tom Daschle of South Dakota. She worked in the Clinton administration. She served as special assistant to the president for legislative affairs. She's a graduate of has her JD from Columbia and her BA from Yale in Russia and Eastern European Studies. She also clerked for Honorable James Oakes of the United States Court of Appeals for the Second Circuit. And so with this wide range of experiences, she's going to bring a lot to the discussion today. She's joined today by our own professor, Paul Kibel. I really want to thank him. He took the lead in organizing this, and he saw the value of this discussion. But I do want to note one thing. We did invite members, scholars from the Federalist Society, and nobody took our offer, so you can interpret that whatever you want to about today's discussion. But Professor Kibel, who organized this, he's a prolific scholar. He teaches in environmental law and water law. He is the director of our Center for Urban Environmental Law, which is our environmental law program, as you know, is consistently ranked as one of the top environmental law programs across the country, and a lot due to the work that he does. He's been a great, wonderful faculty member and I know he's going to bring a lot to the table here for the discussion. But before I bring them up on the stage, I also want to say thank you to the Bar Association of San Francisco and all the people at GGU who have made this happen today. So without further ado, let's bring up our guests, Paul Kibel and Caroline.
So thank you for those introductory remarks, Dean. I wanted to say a couple things at the outset. One, thank you so much for coming out today. We're really excited for this conversation. We are going to be recording it, and there's sort of for two reasons. One, I think the plan is ultimately to post the video of the dialogue in conjunction with Golden Gate's law review. We're also going to be preparing sort of a transcription of the proceedings with an idea towards actually publishing the exchange that we have here as well. And my understanding is also that you are working with the law review on a piece related to the Kavanaugh appointment for the law review as well, so there'll be some scholarly outputs. So I wanted to begin by sort of explaining the format that we've settled on, which I hope should work well. We've sort of divided the dialogue into part one and part two. Part one is really going to be about the confirmation and appointment process that took place related to Brett Kavanaugh. And we're going to spend about 30 minutes. We've worked up some sort of questions and discussion topics about that. After we have that dialogue, we're actually going to open it up to questions on that part of it to the audience and have about 10 minutes or so for sort of questions and discussion with all of you related to that. For part two, we're then going to shift gears and really talk about jurisprudence and talk about issues relating to how having Brett Kavanaugh on the court may change the court's decision-making, looking at issues such as originalism, federalism, executive authority, abortion, women's reproductive rights, views of deference to federal agencies, issues that are really related to what he will bring as a justice on the court as opposed to the sort of appointment process. So, and the last thing I'll mention, just to elaborate, when this began, the idea was really to have three chairs up here. I don't know about three tables, but certainly three chairs. And the other chair was really going to be occupied by a representative from the Federalist Society. That we thought it would be very productive in a sort of a dialogue format as opposed to a speech format to have that type of discussion. We contacted a number of prominent people. Stephen Calabrese, professor at Northwestern, one of the co-founders of the Federalist Society, Professor Oren Kerr at USC Law School, Professor Jonathan Adler at Case Western. We even contacted George Conway III, Kelly Conway's husband, but also a prominent legal thinker on the conservative side, and helped co-found a group called Checks and Balances recently. I'm not going to speculate about the reasons, but we did not have any takers for that. And so we were really left with the decision about whether or not to proceed with the dialogue or to proceed with the dialogue as with just Caroline. And we really felt like the fact that we didn't get a response from the people that we approached was not a reason not to proceed. At least that was.
Well, we got a response. It was just no.
Well, it was the only real no we got was from Calabrese. I think the others were more nuanced.
Yes.
Would love to, but so busy type of responses. But before we get into sort of the format, I did want to give you a little bit of time to talk about how you view the role of ACS in terms of its formation, in particular, as the Dean mentioned, in some sense, sort of its relationship or maybe a leftist counterpart to the Federalist Society.
Sure. First, let me just thank you and the law school, the dean, and all of you for hosting me here and for our ACS chapters that have been involved. I know we have a great, strong chapter here at Golden Gate. I hope you're all members. If not, you can sign up immediately after this discussion. But I also wanted to wish a happy birthday to Ruth Bader Ginsburg, whose birthday is today, and also the dean, who I know is celebrating his birthday this weekend. So anyway, I think that's auspicious to be sharing a birthday with Ruth Bader Ginsburg. May she live forever. And I think she is. I actually had a chance on the plane out here to watch. I finally caught up with the documentary and to see her working out with her trainer and looking quite robust and fit. And I know she's back in full action after her. She is really absolutely a Borg, right? She's had this is her third bout with cancer. She's still doing all her push-ups and workouts and so forth. And she's really indestructible. So it's so impressive. But so ACS, I'd also like to think we're indestructible. But we're a nationwide network committed to the fundamental values of the Constitution. We the people, in order to form a more perfect union. The preamble to the Constitution lays out in such beautiful and empowering and inspirational language what this nation is dedicated to achieving. Effective government, democracy, liberty, and justice for all. And with the post-Reconstruction, the Reconstruction Amendments, we add equality to that list of core values that we believe in, that absolutely infiltrate everything we believe about the law and constitutional values. So I would encourage you, and we have a constitutional law professor here in the room, but next time you're thinking about the Constitution and questions, go back and read the preamble. It's not there just to look pretty at the beginning and have the big W, They wrote beautifully back then. It's actually there to tell you how to understand the document that follows. So that's what we are deeply committed to. So we've been building a network across this country of lawyers and law professors and law students, judges, elected officials, concerned Americans who are committed to ensuring that those values are how our Constitution and our justice system operate. And so it's very important to us to build the next generation, which is why the law students are such a critical part of ACS. You're the ones who are going to transform this nation for the better. And we're at a moment where it's certainly, I think, most of us, even George Conway, some people on the right, many people on the right, understand that we are at a pivotal, dangerous moment for our democracy. We have real stresses in our constitutional system. Our system of separation of powers and checks and balances. I think this is why George Conway, I know this is why, he has founded this group called Checks and Balances, because the presidential power has become so great and the congressional power has been withering. But so that's just to say, we are here, we exist because of you, because we want to work with the students as well as their mentors, the wonderful law professors you have here and the lawyers you'll work with along the way, to make sure that you succeed even where we might not. And that is to make sure that those enduring values in the Constitution really do see themselves expressed in legal decisions by judges, and many of you, some of you, few of you might become judges. I'd encourage you to think about it. In cases brought by the others of you who are going to be practicing lawyers or carrying out the ideas expressed by the law professors that you may become, or the civil rights lawyers, the environmental lawyers, or you could be a corporate lawyer and do pro bono work. But there are so many ways in which you are going to be responsible for making this world a better place, and not to put all the burden on you, but that's really what ACS is all about.
Okay. So we're going to dive into part one, and just sort of in preparation for this, we sort of discussed and came up with sort of 5 subtopics for part one and part two, and we're going to proceed with the dialogue. So I'm going to start with topic number 1. This is related to matters of confirmation, relating to the confirmation. And it really relates, so I'll just lay it out for you. Fairly late in the Senate confirmation process for Brett Kavanaugh, California Senator Dianne Feinstein went public with certain allegations by Dr. Christine Blasey Ford related to alleged sexual misconduct that occurred at an earlier period of life by Brett Kavanaugh. And after the disclosure of the allegations by Dr. Ford, several other women came forward with allegations of sexual misconduct, and there were also related allegations related to excessive drinking that often by Brett Kavanaugh that tied in with some of those allegations regarding the sexual conduct. So, and then in the context of the actual Senate confirmation hearing, both Dr. Ford and Brett Kavanaugh testified and responded to questions related to those allegations. I'm just sort of framing that. So my question for you is, what are your thoughts about the extent to which the process in the Senate confirmation hearing was fair? And in using that word fair, I'm saying both in terms of being fair to Dr. Christine Blasey Ford, but also being fair to Brett Kavanaugh as well, and do you think there are ways that it could have been handled better?
Well, before I get into the specifics of the Kavanaugh process, I do think it's really important to put this in a bigger context, and that is the process by which this White House and the Senate Republicans have approached judicial nominations generally, and looking back to President Obama's final year in office when Justice Scalia died, and there was a vacancy created on the Supreme Court, which in every other presidency would have enabled the president to fill that vacancy. But because Senator McConnell, who's the Republican leader, had been basically obstructing every opportunity that President Obama had to fill any judicial vacancy for 2 years, they declared immediately after Justice Scalia passing away that President Obama would not be able to fill that vacancy, no matter who he nominated. You know, and President Obama, being President Obama and a great conciliator, somebody who tried to reach across the aisle frequently, some people might think too frequently or naively, and perhaps particularly so in this case, nominated a wonderful judge named Merrick Garland, who is a wonderful judge, but is definitely one of the more moderate members of the DC Circuit, on the older side, and white male, really trying very hard to bring along the Republicans, all of who had served in the Senate when Merrick Garland was nominated to the DC Circuit, who had supported him. And in fact, had even said very affirmatively before Barack Obama nominated Merrick Garland that if he were to nominate somebody like Merrick Garland, well, of course, we would support him. This is what Orrin Hatch said. But since once it was, in fact, Merrick Garland, all of a sudden they couldn't support Merrick Garland. So I'm giving you a little of this context because I think it's important to understand how bitter the Democrats were. How very much the Democrats felt, and many people feel, that the Gorsuch seat was a stolen seat. And that the Supreme Court's makeup is illegitimate because the person who should have been on that court, it should have been Merrick Garland, and yet it wasn't. So there's just a lot of anger and distrust that permeates this whole process. So then when you get to Kavanaugh, I think the system had really broken down even further because Brett Kavanaugh, the president had actually been told by McConnell, don't nominate Kavanaugh. Kavanaugh was not on the original list because Brett Kavanaugh has a record that included millions of pages of documents. They were at the National Archives because he'd served in government for so long, had been in the White House counsel's office in the Bush administration at a time when the president had expressed an incredibly extreme view of presidential authority, which involved signing statements that suggested that over 1,000 provisions of federal statutes that Congress had passed were unconstitutional and basically saying, I don't have to abide by these. Brett Kavanaugh was involved in all of that. He was also worked on the impeachment of President Clinton, the Starr Report and so forth. So there was just an incredible, massive amount of documentation that in any other circumstance would have been produced to the Senate, would have been an object for the president, for the Senate to spend a lot of time researching, to read, get a better sense of who is Brett Kavanaugh, what he's been involved in. That was not produced. So let me just say how illegitimate this was, that not only did the Republicans not allow those documents to be produced, the National Archives said they could do it, it just was going to take them a little bit of time. So they said, we can get this smaller amount of documents for you in, by 6 weeks from now. But even that, the Senate Republicans refused in the White House. And instead, they put in charge of the process a White House operative named Bill Burke, who in the Bush White House had actually worked for Brett Kavanaugh. He worked for Brett Kavanaugh, so was involved, most likely, in a lot of the most controversial decision-making that Brett Kavanaugh was involved in. So think about somebody who is very self-interested in making sure that the documents that might implicate Brett Kavanaugh in any type of illegal actions by the Bush administration. Remember the torture issues, detainees, illegal warrantless wiretapping. This was all the kinds of things that Brett Kavanaugh was likely involved in. And Bill Burke, as a result, also involved in. And so they culled out of this much more massive trove of documents a very, very, very limited set of documents pre-approved by Bill Burke in the White House and given to the Senate. And the Democrats barely got to see those. So I know this is a long answer, but I think it's just a sort of we haven't even gotten to the sexual assault issues, but we're already at a place where, building on all of the anger and distrust about the Merrick Garland process, now you have a situation where the nominee is shrouded in mystery. And so that produces even more doubt, because people were wondering, well, what's there? What are you so afraid of?
So I think the comments sort of setting it up are completely relevant, and I appreciate it. I guess if you can speak directly, I think both across the political spectrum there were people that felt that the way the Senate confirmation hearings proceeded were unfair or maybe disrespectful to Dr. Blasey Ford. There were also people on the right who felt that it was unfair in some ways to the timing of it, the nature of it, to Brett Kavanaugh. I'm just interested in hearing your thoughts in light of what you just explained about the process itself, and what your views are of it in ways, given the allegations that were made, how it might have been handled better.
Right. Well, so I think most of you probably recall, we're all kind of riveted on it, that there were actually several women who came forward. And because in support of Dr. Ford, or with their own allegations, and it seemed like a critical matter to get to the bottom of. And Senator Flake, Republican from Arizona, asked for an FBI investigation. However, again, it was in form, but not substance, because they also imposed great limits on the FBI. They did not actually talk to most of the people who were named to support the statements of these women. It's just a very small portion of the people that Christine Blasey Ford mentioned, and then not exploring the charges brought by any of these other women, and done in a very short fashion, produced to the Senate, I believe the day before the vote, in a single copy for all the senators to see. They have to go to the secure location one by one to read it. So, is this a process fair? I think it was a circus. It's so, it obviously, the more I talk about it, brings back so many bad memories. I just, I would love for a moment, if we could change this whole process and have a system where our judges were chosen in a rational way to be people who are committed to upholding the values of the Constitution and interpreting the law in a way consistent with core understandings of legal interpretation. And that it wasn't this terrible system, but I have never seen anything like this, and I've been involved in a lot of judicial nominations battles, but I think what happened with Brett Kavanaugh, one of the reasons I think he's going to bear a stain for however long he serves on the court, is that very few people are going to think that he's there entirely legitimately, because there's so much we don't know, and it may still be, and it is very likely to happen, that the documents that were not produced will be made public at some point in time. And we will start to actually know what Brett Kavanaugh was involved in. And when you have a Supreme Court who then, when one finds out, has had his fingerprints on all of these kinds of decisions, I think that's going to be a profound moment for us to think through whether we have a process of selecting justices that is all rational or appropriate.
So to sort of segue from that, I'm going to skip over one of the comments because you already hit on it in terms of the FBI investigation. But, you know, after Brett Kavanaugh testified, there were certain statements that were made about, and it was sort of in the context of Dr. Ford's allegations, that he viewed the whole presentation of the allegations as part of a sort of larger Clinton-inspired conspiracy. He listed a number of people that he thought were associated with this conspiracy, sort of to attack him and discredit him personally. And after watching this, retired former United States Supreme Court Justice John Paul Stevens issued a public comment, which was somewhat controversial, which was that having watched Kavanaugh's response to the allegations, particularly sort of laying out this sort of conspiracy theory, that he thought that Kavanaugh lacked the temperament and the impartiality to serve on the U.S. Supreme Court, this coming from a former U.S. Supreme Court justice that was appointed by a Republican president. So I guess my question for you, and it's a pretty open one, is, essentially, what do you make of John Paul Stevens' comments? Do you think they were appropriate under the circumstances, and how do those types of comments speak to the point you just mentioned, which is, you sort of called it a stain, but do statements like that during the confirmation process really go to the credibility of both Kavanaugh as a justice and maybe more importantly sort of the Supreme Court and the judiciary as an institution?
Well, I think...
Is that a narrow question?
No, yes, it is. And I think what Justice Stevens put his finger on was something that was very troubling to people who watched the hearings. And did all of you watch the hearings? Mm-hmm. Yeah, so it was deeply upsetting in so many ways to see Dr. Ford testify, the trauma, and then to have Brett Kavanaugh react in a way like he was a victim. And his tirade, I think, was very off-putting to people who don't expect that. If you've watched judicial nominations hearings, particularly Supreme Court hearings, the nominees make an enormous effort to be very calm, to exude judicial temperament in the process, and not to be petulant or angry or indulge in a tirade. And so I think it was just for people who were sort of expectations were really upset. And I think what Justice Stevens was reflecting was we don't really, we're not comfortable with somebody who's going to sit on the Supreme Court who behaves this way in front of a nominations hearing. What does that bode, considering what we are used to? So I think a lot of it is just, expectations about how judges behave, and even if subject to questioning that some people might feel was unfair, or the allegations, perhaps not everybody thought that it was appropriate to bring those forward. Even so, I think just the demeanor was deeply upsetting to people across the spectrum.
So a final question that I have, discussion topic, and then we'll open it up. As a result of the November 2018 elections, the Democrats are now in control of the House of Representatives, and some of the Democratic members of the House have indicated their intentions to hold hearings related to Justice Kavanaugh, in particular hearings possibly related to whether he perjured himself as part of the Senate confirmation process. Now that might be separate from what you mentioned about using the hearing process possibly to get at some of the documents that weren't disclosed. But what I was interested in hearing from you about is, what do you make of the prospect of the House holding hearings on a sitting, justice on the U.S. Supreme Court about whether he perjured himself during his confirmation process? And I guess it's sort of two-part. One is, do you see any precedent for that type of hearing by Congress or the House? And how might that hearing sort of speak to the issues that you said about sort of the legitimacy, either as Kavanaugh as a justice or sort of the institution of the U.S. Supreme Court?
Well, I'm not laughing because it's a funny topic. It's just sort of thinking about all the investigations that the House is doing right now. I'm not sure when they were going to get to Kavanaugh. They may have bigger fish to fry. I'm actually testifying myself in a week after next in front of the House Judiciary Committee on the pardon power. So their focus right now is on other issues. The role of whether tax returns should be produced by the president or other matters. So I think it's an interesting question. It is rather unprecedented, although there was a process of impeachment against the Supreme Court justice very early in the New Republic. The justice was actually acquitted and went on to stayed on the Supreme Court. I think it's very it's troubling that Kavanaugh may have perjured himself. Whether or not this is the appropriate way to remedy it, I don't know. I mean, I think it raises a lot of questions about how politicized do we want our court system to be? Do we want to open that Pandora's box of impeachment for justices? Where will it go? I could certainly see people on the right wanting to impeach justices who support women's access to reproductive care. Is that something, will it become a substantive process? So I don't know. I mean, I think it has not been indulged by Jerry Nadler, who's the chair of the committee, I don't believe. But he's laid out a whole list of priorities. I don't think this is up there or in there at all. So if the Democratic president wins in the next election, and the House remains in Democratic hands, would they have hearings? They may well have hearings. Would they start an impeachment process? I still think it's probably pretty unlikely.
Yeah. So we'll open it up to questions, but I just wanted to make one comment because it kind of links part one to part two. One of the things that I find interesting is if the Democrats in the House were to call for these hearings and potentially proceed with impeachment, that would potentially provide precedent for a Republican-controlled House to do that against appointees by a Democratic president. So when you switch the roles, the question becomes: is this a precedent? And I think it relates to some of the discussion we'll have in part two about executive authority and why some traditional conservative voices are somewhat concerned about the current President Trump's expansive view of presidential authority, because they recognize at some point in time you're going to have a Democratic president back. And any precedent that you establish for extensive presidential authority is not going to be limited to conservative presidents. It's going to apply. So there's some complex issues. But with that, I think we've just looking at where we are time-wise. Let's spend about 10 minutes opening it up. And I'd really ask for right now, if you could focus your questions really about the confirmation and appointment process. We're going to have a second opportunity for questions really related to matters of jurisprudence related to Justice Kavanaugh. So let me open it up now. Yes, if you can identify yourself, that's
Sure.
right.
John Dollinger, I'm a volunteer and I teach election law. My question is, since I think it's unlikely this president called or would call you for advice, but the next president might, as Professor Kibel just alluded to. And so in a scenario where the next president has made an appointment that ACS thinks is a good appointment on all the issues, one of our Supreme Court justices from California perhaps, and something similar emerges during the confirmation process. Someone comes forward, whether it's a sexual assault allegation or something else that's explosive and personal, and the president called you, the day after that came out, would you advise the president to immediately withdraw or stand behind the nominee, or what would your advice be?
Well, I don't. I think it's really important to make sure that we take allegations seriously. I think we're all, reeling somewhat from what's been happening in Virginia, and I don't think progressives want to be hypocritical. It can't be. It shouldn't be hypocritical on these really important issues about whether there has been behavior that violates someone else's liberty, personal autonomy, and so I think they have to be taken very seriously. Whether that means absolutely the minute somebody says something withdrawing, that seems like the wrong response because it would offer too easy a target for people who oppose the nominee for substantive reasons to dredge up somebody who might say anything. However, saying that, I do think there has to be a real investigation, and I think what we saw with Dr. Ford was that her allegations did not get taken seriously by this White House and were not explored. I mean, if they had explored them, if there had been a real investigation and it had been shown that no such thing has happened, then I think the stain would have been removed on Brett Kavanaugh. But I think we have to live our values. And I would never recommend to a president to ignore allegations of sexual assault against a nominee. I think that would run absolutely counter. I was actually, like the dean, was an employment and labor lawyer before I went to work on the Hill. These issues are very important to me, and some of you may have been at a book talk I did a couple of years ago on my book, Under the Bus, How Working Women Are Being Run Over, which explores a lot of issues around race and gender in employment particularly. And I was the general counsel and legal director of NARAL, Pro-Choice America. I'm absolutely committed to gender equity. And I think I would certainly hope that any president who would call me for advice would be similarly committed. So I hope that answers your question.
Yes.
My name is Tiffany. I'm a 1L here. So you had mentioned that if documents were released in regards to more of what Kavanaugh has been involved in, that would lead to more of an initiation for the Senate or for the courts to change the process of selecting justices. Why is it that numerous sexual allegations haven't been able to do that? Why is it that we need those documents to come out?
Well, I think you maybe can, not quite exactly what I said. Number one, it's important to have a thorough review. For somebody who has a lifetime appointment, where we've never impeached a justice, a lifetime appointment, sitting on a court that I think is so enormously powerful, perhaps more powerful than it has ever been in terms of the impact on the American system of government, democracy, on personal autonomy. So the idea that we confirm somebody with having less than 1/10 of the documents that were available is extremely troubling for any normal process, and has not been allowed to happen in the past. I mean, the issue with Kavanaugh was just that the volume of documents was enormous. That was their problem. They picked him. And that shouldn't have denied senators the ability to review his record. It's his record. Just because it was big, it shouldn't take it off the table. The issues of his personal conduct are separate, and a separate reason to raise concerns about him. Again, it might have been that they went through all the documents and found out that he was never worked on any of the troubling issues, or he never perjured himself, which is one of the allegations about when he was nominated to sit on the DC Circuit. He was asked about his involvement in decisions by the Bush administration, and it seemed like he actually said things that were not true. And so there were concerns that he had already perjured himself in his prior hearing, And so without all those documents, it was hard to know, what he'd been involved in and whether he had already lied about it. The personal allegations were a different set of issues. They're separate problems for him, and not you can't just sort of say, one didn't work and so therefore the other. I think you have to remember that these are two very different, areas of concern that were raised about Brett Kavanaugh.
Yes.
Joe Hutchinson on the 1L. In light of Justice Kavanaugh's accusations that there was some kind of conspiracy going on, did you find it alarming at all that all of the sexual allegations against him were dropped?
No, actually not at all. What I find alarming is that Dr. Ford is still in hiding. She's actually still under personal death threats, has not been able to get back to teaching, and I'm very close to somebody who has been regularly in touch with her, who also had worked with Anita Hill. No, I mean, I think, if you look at sort of the, what happens generally, I mean, very few allegations of sexual assault actually brought forward by women particularly, but by all who were assaulted. They're not necessarily actionable legally at the point they're brought forward. These women weren't expecting him to go to jail. I think they were really concerned about the idea that he might be on the Supreme Court for the rest of his life and have the ability to affect all of us in ways that are very hard to remedy. Apart from a constitutional amendment, Congress can do very little when and even if it's a statutory decision, it's very rare for Congress to overturn the Supreme Court. So actually, no, I think, sort of the legal process versus whether he should be a justice. We weren't engaged in the courtroom. He wasn't on trial for rape or sexual assault. The question was, should he have this incredibly privileged office of being a Supreme Court justice when there are these blemishes on his character? I think it's a totally different set of questions and a totally different standard.
Yes, so we'll take one more and then we'll.
I'm Kibel, I'm also 1L here at Golden Gate. And my question is with regards to the nomination process itself and appointment of justices. In an area where we hope to minimize politics and have a review of our laws, is there a way that you see, absent a constitutional amendment, to make that happen and avoid situations like we had with Garland and now with perhaps Gorsuch and Kavanaugh, to where it is their presence or lack of presence on the court is a direct result of politics?
Yeah, well, thank you. That's a great question. Actually, there's a lot of discussion now about possible reform ideas for appointment of judges and justices. There are many who would argue that there should be term limits for Supreme Court justices, some for all of the federal judges, including Steve Calabresi, who wrote a law review article with a more liberal scholar about term limits. And one of the reasons is that in past times, serving on the Supreme Court was kind of the capstone of a career. It wasn't your career. It wasn't, you don't get nominated fairly young to serve on the Supreme Court. It was actually like Earl Warren. He'd already been governor of California. He'd had this incredible record of achievement, and he went up to the Supreme Court as sort of an elder statesman. The average time of service was 18 years. It's now become such a long period of time that that justices serve really out of whack with the way it has been traditionally. So Stephen Calabresi and another law professor have proposed this 18-year terms. He thinks it should be a constitutional or needs to be a constitutional amendment, but many others argue that it doesn't need to be. A lot of constitutional law professors, and you're probably familiar with all this discussion, who think that actually there's no reason that you couldn't create a senior status for Supreme Court justices just as there is on the courts of appeal, on the trial courts in the federal system. And you could even keep the 9. 9, by the way, not in the Constitution. So just FYI, it's a statute that sets the number. But so you could have your group of 9 refreshed regularly, and then the ones who go on to senior status after a period of 18 years could go off and ride the circuits. And, so there's a whole literature about different ways to depoliticize the process. You could take the decisions about which cases the court hears away from the justices and their clerks, who have become more and more political over years, and make that a decision of a group of judges drawn from the circuit courts, or a kind of a group of law professors and judges. There are lots of different ideas about how to approach this, but I think there are many people, certainly among those that we work with, many academics, who are thinking really that the system is not functioning very well. I don't think the progressives don't want to just do the mirror of what the right did and jam somebody down, somebody who doesn't have the respect or support of many. I mean, Ruth Bader Ginsburg, for those of you who watched RBG, she got 93 votes in favor. So she didn't go on the court with this. She had, as Orrin Hatch said in the documentary, well, I didn't agree with her on many things, but she was certainly qualified, and that's the president's prerogative. And so she serves on the court without this cloud hanging over her head of that she shouldn't be there because the process was warped. And I think it's very unfortunate, and you see the sort of the stature of the court going down and down in the views of the American people, because they see this process and they see the nominees as not being exactly legitimate, or being just as much political players as senators and House members and the president. So I think it's something I'm very interested. We have a lot of literature on it. I would encourage you to look at it. I'm very hopeful. Because, as I said, I find the process pretty sickening. I would rather spend my time on other things than an increasingly politicized, nasty partisan process to choose people who are supposed to be impartial and neutral. It really is not. It's not the best way to do business.
Okay, so we're going to move on to part 2. We are going to leave matters of confirmation behind and move on to matters of jurisprudence. We have a pretty meaty list of topics. I'm not sure we're going to be able to get to all of them, but we will start. So, matter of jurisprudence number 1, originalism. So, without getting too far into the jurisprudential weeds, originalism is a school of jurisprudence that was certainly embraced by former Justice Antonin Scalia, also embraced by current Justice Clarence Thomas. It's an approach that holds sort of, in general, that where you have constitutional language that is fairly open and is susceptible to multiple interpretations, and you are a judge reviewing or interpreting that language, the judge should select the interpretation that is most consistent with the understanding of the people that initially adopted it. That you go back to that period of time, and that's the interpretation. So the question that I have for you, and I'll start with a fairly open question, and maybe we can get a little bit more specific, is what are the indications that Justice Kavanaugh will embrace an originalist approach, and how might this affect some of his decision making? Before we get into it, though, I want to bring in a discussion that we had on the phone as we were preparing for this, which I think is somewhat relevant. One of the things that Caroline and I talked about when we were planning this was sort of an interesting question, and I'll pose it to all of you, and maybe you'll pick up on it if you want, which is, were the Founding Fathers originalists? Or framed another way, did the Founding Fathers desire or expect that their particular notions of what the constitutional language meant should be controlling on future justices? And I think where this conversation came up is that there are certain provisions in the Constitution that are very precise, right? Federal courts have subject matter jurisdiction over diversity and federal question. They weren't vague about that. They were very specific. Issues of how many representatives each state gets, or how many senators each state gets, or the way the veto process works. The drafters of the Constitution were very clear and precise in those areas, and yet in other areas they chose language like due process, right to bear arms, freedom of the press, much more open language. And, you know, I think what this raises the question of is, was the choice of using that more open language that was not defined in a precise way sort of an indication to provide latitude to future judges to interpret those terms as they deemed appropriate in the context of their times? Because if they had wanted to lock in a particular meaning, they could have done so, and they didn't. So I'll let you answer this question, and with one last comment. I was with my daughter, who's 14, just turned 14, and she's reading Romeo and Juliet. And we were noticing, as we were talking about it, that Shakespeare, in general, as a playwright, provides very little direction in terms of staging, direction, or costume, right? In terms of how people, very cares about his words a great deal, but in terms of how you produce it, no. So when people say, well, are you putting on the play in a way that's, you know, true to Shakespeare? Shakespeare didn't have any particular notion of how you were supposed to produce his plays. That's sort of reflected from the way he wrote his plays. So with that question hovering out there,
I seem to
Brett
remember
Kavanaugh.
One very famous stage direction was something like Exit Chased by a Bear.
Exit Chased by a Bear.
One of the
but what type
plays.
of bear?
I don't know. It was in the Winter's Tale or something. Anyway, so great question. I think, as you said, there's really no indication that the founders were originalists. In fact, to the contrary, Thomas Jefferson said something exactly to the opposite, that, you know, we shouldn't basically have the dead hand of history determining what we should do in the future, and that we should be renewing our Constitution at regular intervals. I think every 20 years or something like that. And in fact, I think, you know, it's instructive to think about what Chief Justice Marshall said. It is a constitution we are expounding, meaning very much that, you know, it's the role of judges to certainly the judicial review, but also that it's not a statute book. It is an inspirational document meant to set the general values to guide judges in our nation in how the laws will be adopted and implemented, but very imprecise in a lot of issues. And the irony with those who call themselves originalists is that they attempt to lock down this vague meaning in areas where it's convenient, say the Second Amendment, you know, the right to bear arms, while ignoring the language at the beginning of the amendment. And Justice Scalia actually said, well, it's just whatever verbiage. You know, remember the militia clause, surplusage, or I can't remember the exact word he used, but basically ignore the man behind the curtain, right? You know, just pretend that didn't exist. And yet historians could tell you that, you know, that the states were very concerned about their militias being disbanded. And therefore that language was really important to them, because the Second Amendment was about their militias and the preservation of the independent militias against what they feared was an overly strong federal government. And so, you know, you could spend a lot of time, and I can find my historian, and you can find your historian, and we can debate without ever, you know, finding evidence that James Madison said, my dictionary is better than your dictionary. And therefore, you know, we should append that to the Constitution, only look at Webster's as opposed to the Oxford, you know, whatever. So, you know, anyway, I think all being said, Kavanaugh's kind of, he's sort of originally, you know, an originalist-ish, has not expressed you know, he's not given lots and lots of speeches about it, but I think you could say he's generally a follower of that approach, but again, it's something of convenience, and when it works, you use it. When it doesn't work, you abandon it. And I think the Fourth Amendment is a great example of how this plays out generally with originalists. So Randy Barnett, who's a well-known law professor, expounder of the originalist approach, does say that it's actually kind of hard to apply originalism to a lot of contemporary questions. It's like, well, okay, except the ones that you think we can apply it to, right? So in the Fourth Amendment context, somehow you can draw out of the protections that existed in the Fourth Amendment for your house and your personal effects, right, from government intrusion. And we can say in the modern times, well, it's logical to extend that to your cell phone, or GPS tracking, or if you grow marijuana in your basement, to when the cops come by with their thermal imaging systems and determine whether you have a heat lamp in your basement. It's probably not a problem anymore in California. It's all legal here, but just to say, the conservative justices thought that was fine, and somehow that's not living constitutionalism. That seems to me that is exactly what the sort of more progressive constitutional law scholars would say, which is you look at the kind of the principles behind these provisions, protection of your personal autonomy from government intrusion, and that should protect those kinds of what's on your computer and maybe your body. And so forth, but somehow, I think that's one of the reasons that originalism is critiqued so easily as being very outcome-oriented and basically only ever produces conservative outcomes.
So, quite apart from sort of general critiques of originalism, given what you know about how Brett Kavanaugh approaches it, do you see certain types of issues, constitutional or otherwise, where you see him, whether you agree with it or not is a separate question, but where you anticipate or see him applying an originalist approach to those issues or those constitutional questions?
I think it is sort of an ad hoc. He's not been extremely doctrinaire. And so I think he is going to be in the same camp that Gorsuch is in, that Scalia was in, that when it works, and when it doesn't, you abandon it. So not like Clarence Thomas, who is kind of uniquely almost consistent in his approach to, he wants to throw out every precedent that he believes is inconsistent with his view of the Constitution. It's a very radical idea when how many of you are, so a lot of you are 1Ls, 2Ls in here? Any 2Ls or 3Ls? So you spent some time talking and thinking about stare decisis and sort of the way that the common law develops. One of the things that I think is very frightening about the kind of the people who consider themselves or call themselves extreme originalists is their willingness to abandon that approach to kind of the evolutionary process of the law, something that gives our legal system stability, gives litigants some idea of what the law says. It is profoundly a sort of element of rule of law. People know when they go into a courtroom basically the law that the courts will apply. And somebody like Clarence Thomas will just throw that out the window, and it doesn't matter how old the precedent is or how long it's been relied on by courts subsequently. If he thinks that it's not consistent with his view of the Constitution, it's got to go, no matter what impact that has on the legal system. Kavanaugh's not like that. I mean, he's more consistent in wanting a conservative outcome. If originalism works, you'll use it. If it doesn't, you won't.
So we've got a couple questions here. I'm going to turn to the one about presidential authority just to make sure that we get into that. So another important constitutional question that comes up is the issue of the scope and limits of presidential authority. Now, in terms of Neil Gorsuch, who also at times is an originalist, my understanding, and you can correct me here, is that one of the tenets of Gorsuch's originalism is that he thinks the Founding Fathers were particularly concerned about excessive presidential authority, essentially the prospect of the president becoming a king that was above the law. So Gorsuch is an originalist that ends up, at least in some of his scholarship, taking a somewhat limited view of executive branch authority because he thinks that's consistent with the Founding Fathers. My understanding is that at least in his legal career, some of his opinions, but also some of the work he did in the Bush administration, Kavanaugh's an originalist that has not come to the same conclusion as Gorsuch. and actually views executive authority very expansively. So we'll talk a little bit later maybe about the border wall and a little bit more specific, but to open it up more generally, do you see potential tension or clashes between sort of Gorsuch and Kavanaugh on this issue of executive branch or presidential authority?
Well, you know, it's
Sort of a rift within the conservative wing of the court.
well, I certainly hope so. In part because I think there's so much at stake. The Supreme Court may have cases in front of it that deal with the Mueller investigation. And, you know, I think this is going to be a very important question to see if the conservative justices all step up to protect the president at the expense of checks and balances, at the expense of rule of law. Will Gorsuch break? I don't know. I mean, I hope so. But I think it's really important to know sort of what tradition Brett Kavanaugh comes out of. There's something called the unitary executive. Have any of you encountered this? Yes, you have. So, you know, this is a view as expounded by Stephen Calabresi, that all executive power resides in the president. And therefore, everything that happens in the executive branch is ultimately must be determined by the president. That is, he can hire and fire everybody. Congress has no ability to delegate to these administrative agencies. There's a whole set of building up of the presidential power in an extreme way that is very controversial, especially because the Constitution does not say all executive power shall be vested in the president. And even, you know, the original Constitution separates power not just between executive, judiciary, and legislative, but also among the branches there are different. And at the time the Constitution was created, there were prosecutors that were run by judges, that were appointed by judges. There was a whole array of ways that things were mixed constitutionally. But this vision means that the president can, you know, that the Congress can't put any limits on the president's ability to fire somebody. So creating an independent prosecutorial model like a special counsel is very illegitimate under that view. And so that's where sort of this tension will come up. You know, is the investigation legitimate? Could the president simply terminate Mueller or any of those others without process? And I think that case may well be coming, right? Does the president have to respond to a subpoena? Is the president, in fact, above the law? And, you know, I think, as you said, the possibility that Gorsuch thinks that, and I think it's self-evident, personally, that one of the reasons we had a revolution was to not have a king, was to not have somebody with absolute power, but in fact to have a democracy subject to checks and balances. I think Kavanaugh's view is very frightening and is not just ahistorical, but is actually contrary to a fundamental understanding of what gave rise to the American Republic.
So I'm going to segue from that sort of more general discussion about executive authority to some more current events dealing specifically with the wall. I may encourage you to speculate a little bit about it, given what you know about Kavanaugh's approach, about how he might approach this. So, as many of you know, last month, after Congress did not provide full funding for the border wall with Mexico, President Trump issued a national emergency declaration where he indicated that he was going to reallocate certain funds from the military and the Defense Department to make up for the shortfall to complete the border wall. What is interesting to note, and I will welcome your thoughts on this, Caroline, is that in connection with Trump's declaration of the national emergency to complete construction of the wall, the border wall, many leading conservative voices, not ACS, have taken the position that the president's use of a national emergency declaration to complete the wall is inappropriate. And the two that I wanted to mention specifically are the magazine The National Review and the Cato Institute in Washington, In February 15th, the National Review wrote that President Trump's national emergency declaration, quote, is the proclamation of a monarch, not an argument by a president. I think this gets back to King George III. And that it should fail in court. The National Review article went on to state, quote, a border wall is a civilian structure to be manned by civilian authorities to perform a civilian mission. The troops would not be creating a military fortification for military use. Not only is the wall not military construction, it's also not necessary to support the use of armed forces unless one wants to make the fantastical argument that the wall somehow protects the troops who are building the wall. Cato Institute, sort of well-established conservative voice, wrote also February 19th, 2019, an article on it, Cato at Liberty blog, quote, no reasonable person can look at the southern border and agree that it rises to the level of a national emergency. The Cato Institute article continued, quote, the most common argument in favor of a national emergency is that there is an epidemic of immigration-induced crime and death on the border. This is simply not the case. The crime rate in the 23 counties along the U.S. border with Mexico is below that of the counties in the United States that do not lie on the border. Violent and property crime rates are both slightly lower along the border, and the homicide rate along the border is 35% below the homicide rate in non-border counties. Resident illegal immigrants are less likely to be incarcerated or convicted of crimes than native-born Americans. The estimated illegal incarceration rate in 2016 was 47% below that of native-born Americans. So where I'm going with this is, one, I'm curious to hear about the extent to which ACS as an organization is actually collaborating or in discussions with groups like the Cato Institute and National Review, whom you often don't align. And two, as you think about a case coming before the US Supreme Court over essentially whether this national emergency and using these funds in this way is constitutional, and Justice Kavanaugh, how does information like this coming from the right, coming from the National Review, the Cato Institute, affect, do you think we're obviously speculating, but might affect the way that a justice like Kavanaugh would approach this question?
Well, I mean, it's a very good question, and it is important to understand that these public expressions of concern are really rather new from many on the right, particularly the National Review. Now, Cato is a little bit different, and if you're not familiar with Cato, it's a libertarian organization. It has always stood a little bit apart from the Republican Party, was outspoken in favor of gay marriage, and so in limited areas, and immigration is another place where it's an organization that we have been able to work with. The National Review, however, is generally extremely conservative on pretty much everything. And so that was very interesting to see expressions of concern coming out of that quarter. But I think what we're seeing is that, for these conservative organizations that have sort of been identified with the idea that we should have a small government, that we're worrying about overweening power, even if they think that perhaps in the constitutional structure the president is stronger than we might think the president should be. The federal government still should not be that enormous and powerful. And I think looking at the president able to override what I think traditional separation of powers, that Congress is the body that appropriates and determines where money goes. It's sort of the classic determination of what the Congress does is the budget, and that the president can simply ignore. I think is very troubling to them. So I think this does it may give some ability or give for the conservative justices to feel a little bit more empowered to start to question the president. In the travel ban case, they didn't do that so much. So we'll see. But I even if the justices don't, there's I think a lot of unease among those on the right who see, who really worry about where this could be going. I mean, the idea that a president could redo the appropriations process without, in fact, in ignoring, in this situation we have here, is that Congress was in the Republican control for 2 years of Trump's presidency and never funded this wall, despite Donald Trump asking them to. So basically, rejection of that funding demand. So we have a direct clash here. It remains to be seen. I think Kavanaugh himself has expressed extreme deference to presidential authority and this idea of the unitary executive. Whether Gorsuch or John Roberts is willing to go along with that, that's where your questions are.
We don't know. And obviously some of the concerns that we're seeing here are related to any precedent that would be established by upholding President Trump's ability to do this with the national wall could be relied on by a Democratic president for other national emergencies. I mean, I think Nancy Pelosi hinted at, national gun violence. We think that's a national emergency. Climate change. So there's some recognition that the argument, while it may support a Republican president now, could establish a precedent that would be
in areas where you could show that there was an emergency.
Yeah. So this is I'm going to skip ahead to our fifth topic, partially because of time, but partially because I think it relates to the executive. And this relates to the issue of judicial review of administrative agencies. And this is actually a little bit more in my wheelhouse because I deal with natural resource and environmental agencies, and the relationship of judicial review of agency action is a big part of that. So as some of you may know, particularly those of you who've taken environmental law or some courses involving administrative law, about 3 decades ago there was a decision, Chevron, U.S. Supreme Court, which focused on when agencies, federal agencies, are interpreting statutes where the language is arguably somewhat ambiguous or susceptible to multiple interpretations, what should be the role of judicial review in reviewing those agency interpretations? And what came out of the Chevron case is what's known as either the Chevron doctrine or Chevron deference, which is essentially this, that if the agency's interpretation of an arguably ambiguous or open statute is a reasonable one, the reviewing court should not substitute its own view for the agency's. That's the deference part of it. So, and in some sense, because these are executive agencies, especially if you adopt sort of a unitary view, this is essentially the executive branch interpreting it. Sorry to keep pitting Gorsuch against Kavanaugh, but it's very convenient. Justice Gorsuch has done a fair amount of scholarship and some concurring and dissenting opinions indicating that he is somewhat uncomfortable with Chevron deference. And he's questions whether it's appropriate for courts, judges, to delegate to agencies the task of interpreting statutes. He's gone so far as to suggest it may actually be an unconstitutional abdication. Not quite sure where he is on that. But I guess my question is in terms of Justice Kavanaugh, obviously a lot of the work of the government is undertaken not by Congress, it's undertaken by the agencies that implement these statutes. What do we know, or what do you think might be Kavanaugh's approach to this issue of judicial review of agency actions and interpretation and Chevron deference, the viability of Chevron?
Yeah, it's an important question, and actually they are very aligned.
Okay.
Kavanaugh has been extremely critical of Chevron deference. I actually have a quote from him. We wrote an article in the Harvard Law Review where he said, he critiqued explicitly the Chevron doctrine, gave a speech at Notre Dame. He said, the Chevron doctrine encourages agency aggressiveness on a large scale. The unitary executive that theory is inconsistent with deference to agency decision making, because the agencies were given this role by by statute to be able to flesh out. We don't want Congress to write statutes that are going to lay out every single provision in terms of what the EPA should do to understand how many parts per billion of some kind of a chemical you can have in the water and it can still meet the Clean Water Act tests. Right, so that's what Congress writes the statutes and leaves to the agencies to draft regulations based on their expertise and understanding of what Congress was intending. So the idea, the critique of Chevron is that it was inappropriate, that Congress cannot create this system where the agencies have the power to interpret statutes apart from what the president wants them to do, right? So it's sort of flip side of the same understanding of the strong role of the presidency, and it can't be divided and given, undermined by this kind of independence of these executive branch agencies. So the two of them are both, quite consistent, together on this, and I think, for those of us who believe that they're actually, many of these statutes that have been interpreted by the agencies, including the Clean Water Act, the Clean Air Act, worker protection, areas like the OSHA Act, the Occupational Safety and Health, that it's critical that you have this expertise in the agencies to be able to, determine with greater specificity than Congress can how to protect people, to make sure that, that children aren't going to school with lead in the water system. That the air we breathe is relatively clean, and that workers aren't working in incredibly dangerous conditions in a factory. So this is, I think, an area where this extreme views are going to clash with what the vast majority of Americans expect their government to do. We've benefited so much from these vital statutes that better than anybody, the clean water. It used to be that rivers, burst into flames in this country before the Clean Water Act was passed from industrial waste. We're somewhat, we've done a lot to repair that, and this extreme view would undermine the agency's ability to do that.
I think, based on my experience with the Chevron doctrine and Chevron deference, one of the interesting aspects is the way it cuts both ways politically. So when I was in law school, learning about the Chevron doctrine, it was the case Chevron, Natural Resources Defense Council versus Chevron, was a situation where the agency had interpreted, this was in the Reagan administration, Bush 1, had interpreted the statute such that it limited environmental protection. So the view was that Chevron enabled a Republican administration to interpret environmental statutes narrowly to undercut environmental protection. But what was interesting to watch under Chevron is then the Clinton administration came in and they issued regulations, and Chevron deference actually upheld those. So it actually didn't really end up being a left-right issue. And what I think is interesting is that if you think about, okay, you're opposed to Chevron deference, well, the Trump administration right now is busy issuing interpretations of statutes to which a court should have no deference.
Well, so
it should substitute its own view. So regardless of which side you may have a different view.
I disagree with that, actually.
Okay.
And it's fundamentally because I think the role of government is seen so differently by Democratic presidents and Republican presidents, and to have an effective administrative state that actually was able to provide these protections for the environment and so forth. Certainly there are going to be some examples where Chevron cuts the other way, but I think that the construct of deference to the expertise in the agencies generally is protective as opposed to, and I'll say this because the way that the courts have approached Donald Trump's efforts to undo regulations has actually been very critical in most places, because what they've just tried to do is ignore the facts and just repeal the regulations. You actually have to go through a whole process, right? You have to have data under the Administrative Procedures Act that has some rational basis for why you're making the changes, and they haven't bothered to do that. So they've kind of gotten caught up thinking, again, sort of the imperial presidency at work, but this administration has not felt that it needs to abide by that kind of rulemaking process, and so so for those of you who are ACS members, which I hope means is all of you, we've actually been engaging our chapters, our members, and a lot of the students particularly to participate in the rulemaking process by filing comments, as this administration has tried to change the rules around a whole variety of issues and women's health care, particularly Title IX, Title X regulations for family planning and so forth, because it's really important to express the views of how these statutes should be understood, what the regulations should look like, because they actually have to look at those comments and they have to account for them. Even if they're going to say, I disagree with it, they can't just say, I disagree with it and that's the end of it. They have to say, I disagree with it and here's why. So it might be, that their arguments aren't very persuasive, but they actually have to put some data in there. So anyway, that's sort of a long answer, but I think why I think that Chevron has elicited much more critique on the right than on the left.
Okay, so we had 5 topics, but I'm looking at the time, and I'm going to cut to the last one, so we have time for questions, and it returns to some of your earlier work before coming to ACS. So I wanted to ask you some questions about abortion and women's reproductive rights. So February 2019, U.S. Supreme Court decision in June Medical Service versus Lee, Justice Kavanaugh, in one of his first opinions on the court, issued a dissenting opinion that advocated for upholding the Louisiana law that imposed limits on when abortions could be performed. So I guess my question for you, sort of using the June Medical Services case as a starting point, is what does his dissenting opinion in June Medical Services, as well as his other opinions on the DC Court of Appeals, tell us about how he approaches the issue of abortion and women's reproductive rights?
I think it gave us a very strong indication of how he's approaching it. For those of you who haven't followed this case, this is an exact repeat of a case called Whole Women's Health. It dealt with the same kind of limitations of the state trying to impose additional requirements on clinics that serve women that are unrelated to medical need, in fact, contrary. Made it much more expensive to run these clinics, made it harder to find doctors. They have admitting privileges at the local hospital, turning the center into basically a full-fledged hospital, and making it basically would result in these places mostly in shutting down most of the clinics and eliminating the ability of women to get reproductive care, including abortion. And so Whole Women's Health was decided, and they found that it was an undue burden under the Casey standard to impose these new requirements. Well, this case presents the exact same issue, and we see where this court will go with one more vote, right? And it was actually surprising that it didn't go, they didn't flip the Whole Women's Health so quickly. It was just, with Justice Kennedy stepping off the court, we're very close to seeing those kinds of cases starting to go the other way. But I think Kavanaugh he announced where he is, and I think we've got a lot to worry about.
Can you tell us, just for those of us who haven't read his dissenting opinion, a little bit about what he announced in this case in terms of what his position is?
I think what he said was they didn't actually, they have to go back and prove that this would actually in much more detail how this would actually limit the clinic's ability to function. They already had all that data. It was a sort of, it was just a way of giving the state another bite at the apple.
So I had some questions in here also about federalism, but I think looking at where we're at time-wise, maybe we'll get to them in the questions and answer, but I want to leave some time for all of you. So let's open it up, and once again, Part 2 is really focused on what we're calling matters of jurisprudence rather than the appointment process. So if you could try to focus your questions there, that would be great. Yes, Professor Christensen in the back.
If I can just ask one, I wonder, and this relates directly to the question you just answered about the Whole Women's Health transition. It seems to me the person is hard to beat right now, is Chief Justice Roberts. It's not keeping me honest that it's hard to beat. But with the court as it's aligned now, there are going to be so many issues, and we already saw that, where we're going to ask whether the court is ready to radically reverse itself from a decision that happened any time in the last 10 years, as we transitioned from a conservative court with some moderates in the middle to a conservative court without moderates in the middle. What do you think is going to happen? Are we going to see decisions where we overturn Casey, more radical option, overturn Roe and Casey, or are we going to see a lot of decisions where we just redefine undoer? Are we going to see an overturning of Obergefell and marriage equality, or are we just going to see increased religious exemptions? And I want you to answer that question, but also in the context of, I'm a lawyer, I'm a constitutional law professor, all I have to do is count to 5. And when I look for the 5th vote to uphold marriage equality on the current court, or to uphold Casey, I can get to 5.
Yeah, well, I think that's math.
Yeah, it's not.
It's not much you can do about that. So math matters. And I am extremely frightened about what this means. So I'd say, I think the Chief Justice does have concerns about the legitimacy of the court and what it looks like to reverse. It's not just reversing a precedent that you could say, well, it's from 40 years ago, times have changed, but to reverse a precedent from 2 years ago because one justice has changed. I think it's very unsettling, the idea that our law is so it's so easy to manipulate that way, and so on such profound matters. So I think he'll be concerned about the optics of that. That being said, he'd like to overturn Casey, and he would have liked to. He wasn't with the majority on whole women's health, so he does not agree. And in this case, he simply was saying, the court shouldn't be doing this way. I think Obergefell is another one where he may try and moderate where the court goes. You'll see Thomas and Gorsuch and Kavanaugh and Alito saying it was wrong, throw it out, whatever the consequences. I think Roberts will try and do the religious exemptions instead and say, okay, you can get married, but if a photographer doesn't want to come to your wedding, that's okay. No matter what the state's statutes say, the human rights statutes say, the florist, the baker, the dressmaker, the whatever. And all of a sudden you'd see LGBTQ people could get married, but they actually can't get married in a church, and they can't get married in a restaurant, and they can be excluded from. And it's very contrary to the way we understand our Constitution and the 14th Amendment, and the implications that religious exemptions can trump these basic fundamental human rights. Where does that stop? Does that stop with race? Is race different? Is religion different? Would you do it to Muslims? Jews? I mean, these are really profound questions, but I think that the chief is going to be I think it's scary enough in the religious exemption. I don't think he wants them to go and overturn Obergefell or Roe in an explicit way, because that gets everybody's attention in a way that these other decisions and don't. So I think 5 is the magic number. And I think for anybody who didn't vote in the last presidential election, I'm not endorsing a candidate, I'm not partisan, but I tell you, if any of these things matter to you, I certainly hope you participate, get everybody you know to participate in the upcoming elections, because these are all choices that are going to be determined by who sits on the Supreme Court, and there will be other vacancies shortly, no doubt.
Yes.
So with the First Amendment,
If you can identify yourself, just because we're recording.
So yes, I'm Matthew Bisson. I'm a 3L here, and I'm also the Golden Gate University ACS president. So my question is, with the way that the First Amendment has sort of blossomed to the forefront in the last few years, do you think that the current makeup of the court is likely to take any large stance about free speech, particularly free political speech, or there's one case in particular that's originating out of Pennsylvania where a rapper was convicted and upheld, that was affirmed by the Supreme Court of Pennsylvania, for terroristic threats in a song.
Mm-hmm.
So I was just wondering if you have any thoughts about how free speech might transform under this current makeup.
Well, yeah, it's a great question. One of the things that is of great concern is in the area of money in politics. the whole line of cases, starting with Buckley, Citizens United. There are still a few provisions of that original post-Watergate campaign finance reform legislation still standing. I think the court may find, that not only, that the spending limits, they're gone, contribution limits. Billionaires can spend as much money as they want on independent expenditures, corporations can. There are very little limits on coordination between, independent expenditures and campaign funds. I think that under the view of the majority on this court, it may all come tumbling down. And we will just have a free-for-all where money is free to do anything in politics. It's very dismaying. I think some of the issues are about kind of hate speech and violent speech, and are more difficult to see exactly how the court comes out. How they dealt with the Patton case, with the slants, and it doesn't. There's no coherence in it, so it's hard for me to kind of exactly. And I don't know if you have any thoughts, Professor Christensen.
It just doesn't break down on the traditional liberal conservative. And it never has.
So that one is one I'm not quite sure. They tend to sort of have their own, bring a lot of their personal views into this, to sort of think about the crush videos. You read those cases, with the gross. I won't even describe them. But I think Alito in that one, even though he wants to dismantle every remaining piece of campaign finance legislation, he's really thought it was terrible that these videos showed little animals being crushed, and that you can limit the First Amendment rights of people watching these terrible videos, but you can't limit the rights of the Koch brothers to intervene in politics in any way they want to. So I think the First Amendment is a mess. This court has completely destroyed any coherent understanding. I actually have to recommend a book called Madison's Music, which is a wonderful First Amendment book, and it sort of talks about the First Amendment as being a democracy enhancing amendment, and how each provision sort of about your own personal conscience, protection of speech, protection of advocacy, basically your ability to petition the government, and sort of it moves from the personal and individual conscience level to the participation in the political process. I think it's very compelling argument for how the First Amendment should be understood, which then leads you to Buckley v. Vallejo is wrongly decided, Citizens United wrongly decided, Free Speech Now wrongly decided, all of those because they don't understand that the First Amendment is actually about enhancing democracy as opposed to allowing rich people to buy it.
Yes. Once identify yourself, just so.
Gabe Fletcher, 1L. In looking at gay marriage, the right to choose, how do we balance out in a constitutional aspect women's right to choice, while in the instance of, say, gay marriage, looking in a different direction when we look at, say, a baker's right to choose or a dressmaker's right to choose who they provide services to? How do you balance out those choice factors and constitutional rights?
I'd say that's a bit of a confusion, I think, in how you pose the question. The 14th Amendment guarantees equal protection of the law to all people. And that means that you can't be denied services, and that under the civil rights laws, which were Congress interpreting the meanings of those constitutional amendments, they understood that accommodations, when you are actually running a business and you're accredited by the government, you have your licenses and all of that, you have to serve everybody. I mean, it's similar to, and have you taken ComLaw yet? So, the famous cases involving public accommodations where was it the Heart of Atlanta? Heart of Atlanta Hotel, thank you. It's been a long time since I was in Boston. Heart of Atlanta Hotel People were saying it violates our religious right. We don't want to have African Americans stay here. Or if they didn't want to serve them in the restaurants, at the lunch counters. It's exactly the same argument they made. There's been very consistent understanding that under our civil rights statutes, there are appropriate understanding of the Constitution that services cannot be denied to people for illegitimate reasons, and that is based on who you are. And so the same argument has got to apply, in my mind, I think in the minds of people who understand the Constitution as expressing those core values. You can't deny people services in this country based on the color of their skin, their gender, their sexual orientation, their religion, their national origin. And so this is just, so if you're practicing your business, just as though you can't deny African Americans the right to stay in your hotel, you can't deny gay Americans the right to stay in your hotel. It's the exact same principle. So I think where it gets distorted is the argument that you're making is the way the other side, the people who want to deny LGBTQ people their full autonomy as human beings, they set that up as a choice, right? It's like it's an equivalent choice. It's not. If you're doing business, it's like any other business. You have to have access for people with disabilities, right? You could say, I would raise a constitutional objection to putting a ramp to come up the stairs into my building because my religion says I shouldn't have to serve people in a wheelchair. But we reject that argument because it's not equivalent. We're not allowing people to discriminate based on who you are as a human being. Immutable characteristic.
So I'm going to exercise prerogative and ask the final question, since it was in our list anyway and we didn't get to it, because we're getting near the end of our time. The topic or question that we had discussed related to federalism, the relationship between the federal government and federal law and state governments and state law. And there are a number of issues related to this, but two of them that we had flagged. One is the issue of federal preemption of state law, and the other is that we do have certain federal laws that in the statute preserve a particular place for state law. And I'll mention two of those and then I'll sort of pose it as a question related to Kavanaugh. The United States Bureau of Reclamation runs a lot of large water projects in the western United States, including the Central Valley Project here in California. Section 8 of the Reclamation Act says that the Bureau of Reclamation has to comply with state water law in operating its projects. The statute says that, which is very relevant in California where we're dealing with fisheries and releases from dams and issues of how they operate those structures. Another example would be there's something called the Coastal Zone Management Act, the CZMA. CZMA provides the federal government with authority to approve certain offshore activities, like oil drilling, but it says that they need to make a consistency determination that it's consistent with state coastal policy, which provides our state coastal commission with the opportunity to adopt policies that the federal government has to act consistently with. So I guess to sort of frame this as a question, if I can bring that back to Kavanaugh, is kind of like with Chevron deference, in general, for the past, let's say, 30 or 40 years, the issue of states' rights has been framed primarily as a conservative effort to restrict overreaching preemption by the federal government. Certainly that's been the case in the areas that I work in, environment and natural resources. Yet now we're seeing what ACS and others have described as progressive federalism, where states like California are looking for a restrictive view of federal preemption and an expansive view of states' rights to protect themselves sort of from what the federal government is doing. What is your sense of Kavanaugh's position on the issue of states' rights and federalism, and more particularly how it might relate to sort of progressive federalism and the use of state law sort of with positions that are maybe more often associated with the political left?
Well, it's interesting. I think maybe federalism and preemption are somewhat akin to originalism and textualism with Kavanaugh. Convenient, yeah, I think it's, and you can see in a range of issues, he's had some rulings in the First Amendment where efforts at the local level to provide greater, net neutrality are preempted. Those internet companies' First Amendment rights are prevalent, or in the, so preemption, he believes in there. Gun regulation, another area where one expects him to be favorable to efforts to preempt, to challenge local restrictions. But when it came to abortion, he's got a different approach, and I think so. It's kind of a mixed bag. It's rather outcome driven. He's certainly very deferential to the state, to Louisiana when it comes to restrictions on women's access to clinics. I think federalism is one of those where we'll find we'll figure it out after we get the outcome.
Yeah.
Work your way backwards.
I think there's and I'm sure you're familiar with it, there's the new, not that new, but the Dean at Yale Law School, Heather Gerken, has written a lot about federalism and progressive federalism, and she coined a phrase which I really think is spot on, which is fair weather federalism. And she said it applies to the right and the left, that people are really not as intellectually or ideologically committed to states' rights or the federal government as they often proclaim. They're more committed to the issues that they care about, and if state law will allow them to get there, they'll argue for states' rights, and federal law. And I think her point was simply that both on the political left and the political right, many of us are actually fair weather federalists, and I think there's a fair amount of truth to that. So with that, I would like to once again thank you for making the journey and sharing your thoughts with us.
Thank you very much.
Any closing thoughts, pitch, insights for us?
No, just encourage you all to join ACS if you're not, got the president here who can sign you up right now. Participate in the process, run for office, vote for people, become a judge, but just participate however you can to make this country a better place. I want to thank you in advance for all you're going to do.
Okay.